I've mentioned before that if people don't like how courts interpret something, one solution is to change the law. And sometimes that actually happens. Here's a perfect example. The Institute for Justice recently sent me information about a major development in Idaho. The governor signed a bill that protects private property from warrantless searches by law enforcement. It's called S 1326, and it's the first law of its kind in the country. What this new law does is prohibit most government agents from entering private land that is closed to the public without a warrant, without consent, or without a recognized emergency. That means if the government wants to step onto your private property to investigate or search for wrongdoing, they must first go to a judge and show probable cause. That's the key: probable cause and a warrant. And the interesting part is why this law was needed in the first place. For decades, government agents have relied on something called the open fields doctrine. This doctrine comes from a Supreme Court case decided during Prohibition, Hester vs. United States. In that case, federal agents hid on private land to observe suspected illegal alcohol activity. The Supreme Court, in a very short opinion, ruled that the Fourth Amendment protections for persons, houses, papers, and effects did not extend to open fields. In other words, while your home was protected, the land surrounding it was not. That ruling essentially removed Fourth Amendment protections from most privately owned land in the United States. Now think about that for a moment. When most people think of their property, they don't divide it into house protected and everything else unprotected. If you own a home on several acres and put up no trespassing signs, you probably assume that your land is private, not open territory for government officials to wander around without a warrant. But under the open fields doctrine, that's exactly what could happen. The common law distinctions the Supreme Court relied on were originally about burglary, entering someone's dwelling at night with criminal intent, not about government agents conducting searches. Over time, those distinctions became embedded in Fourth Amendment interpretation, and the result was that government agents could legally enter private land, so long as it wasn't the immediate home, without a warrant. Idaho just changed that. Before this new law, only a small percentage of Idaho's private land was protected from warrantless entry. Idaho has about 14 million acres of private land. Under the old interpretation, only a tiny fraction of that had meaningful protection. Now, 100% of privately owned land in Idaho is protected from warrantless searches under state law. If law enforcement wants to investigate private land, they now need a warrant. And here's the simple principle behind that. If you have probable cause, go get a warrant. That's how the system is supposed to work. The Institute for Justice has been fighting similar cases across the country. They've represented landowners where government agents place trail cameras on private property without warrants. They've challenged warrantless drone surveillance. I personally attended oral arguments at the Michigan Supreme Court in a case involving warrantless drone use. In that case, a township official suspected code violations inside someone's fenced backyard, a yard completely shielded from public view by a privacy fence. Instead of getting a warrant, they launched a drone and flew it over the property. The township's argument? Code violations aren't crimes. Therefore, they argued, Fourth Amendment protections shouldn't apply. One justice even asked whether allowing such surveillance would really lead to widespread drone overflights. The concern, of course, is that once the door is opened, agencies will absolutely use the tool more often. Drones are inexpensive. They're easy to operate. If courts say no warrant is needed, usage will expand. And this always brings out the same response from some people. If you're not breaking the law, you have nothing to worry about. That argument is centuries old. It predates the Constitution, and it's exactly the mindset the framers were trying to avoid. The purpose of the Fourth Amendment wasn't to protect criminals. It was to protect everyone from unreasonable searches and seizures. It was to ensure that government power would be limited, that officials couldn't simply roam around private property looking for something suspicious. You shouldn't have to justify wanting privacy in your own fenced backyard. Wanting privacy doesn't make someone a criminal. Now, because the Supreme Court's open fields doctrine remains federal precedent, the only way to overturn it nationally would be for a case to reach the Supreme Court again and for the court to reverse itself. That doesn't happen often, but states can pass their own laws that provide stronger protections than the federal baseline. That's what Idaho did. And this law passed with bipartisan support. That's notable. This isn't a partisan issue. It's about property rights and constitutional protections. The Institute for Justice is a nonprofit organization that relies entirely on donations and spends its time litigating these kinds of cases across the country. They challenge qualified immunity doctrines. They challenge warrantless surveillance practices. They push for stronger property protections. And sometimes, as we see here, legislative reform follows. The basic idea is simple. Private land is private land. If the government wants to search it, they should obtain a warrant, just like they would if they wanted to enter your house. That principle makes sense. If there's legitimate evidence of wrongdoing, judges issue warrants every day. Requiring a warrant doesn't prevent law enforcement from doing its job. It ensures they do it the right way. This Idaho law restores that protection at the state level. And it's an example of how, when courts interpret constitutional protections narrowly, legislatures can step in and expand them again. So, yes, sometimes if people don't like how a court rules, the solution really is to change the law. That just happened in Idaho, and it's something worth paying attention to.